Asymmetrical Haircuts Justice Update with Janet Anderson and Stephanie van den Berg in partnership with justiceinfo.net.
Hi, Janet.
Hi, Steph.
Most listeners will know that some weeks we've obviously planned months in advance and we're trying to look at kind of the big trends that go on in our world of international justice.
And some weeks we're just covering what's happened in a court case and we're providing some kind of an instant replay.
But sometimes, like in this week's episode, we have some legal conundrums that we've had to tackle as journalists, and therefore we think it's worthwhile opening those issues up to a wider audience that you can understand the questions that we as journalists also ask in order to be able to write these stories that we do to say what this means and kind of the takes that you see in the news media.
And of course, we're very lucky that we can ask experts to weigh in on an issue. And this week, we've been able to grab hold of two very significant experts in our field and ask them some very specific questions, exactly the kind of things that we get to ask in order to write up the piece.
Because this week we saw two issues that are connected to the investigation by the International Criminal Court into the situation in Palestine. And especially now that we're in a kind of period of suspended animation while we wait for the judges of the pretrial chamber to confirm, or maybe not, the arrest warrants that prosecutor Karim Khan requested be issued against senior Israeli and senior Hamas leaders.
It's exactly this kind of cucumber time, isn't it? That when you get media saying, give us another story, what is there some way of covering this? And then you get so much attention on these kinds of speculative things. But anyway, before we go any further, why don't you give us a blast of Stephopedia to get us all up to speed on this?
Oh God, when I saw this in the script, I had to immediately check all the dates because I had forgotten all of this. But this is very broad brushstrokes. So Palestine has been trying to join the ICC for a long time. It already asked in 2009, and then prosecutor Luis Moreno Ocampo said no because it's unclear that Palestine is a state. Then we saw this process of the Palestinian authorities applying to the UN and eventually being granted observer state status at the UN. And then they asked to be an ICC member in 2015.
Just going to interrupt a moment in your Stephopedia-ness there, because I found an interesting comment as I was researching recently to say that, in fact, there's some speculation that it was the application to join the ICC that really pushed Palestine to apply for this UN observer state status at the UN. So it's kind of interesting that interplay. And before you go on to the next bit, I'm just remembering that they did actually become a member of the ICC. I was at the Assembly of States Parties where that just went through basically on the nod early one morning in New York. So then there they were, a member of the ICC.
And then the ICC opened a preliminary examination, the kind of pre-investigation stage they have. But Palestine had been pushing for them to open a full investigation, and that didn't happen right away. So then in 2018, they referred the situation in the territory of Palestine to the ICC as a state party, which it's, you have some discretion as a prosecutor. Often it meant that they would open an investigation right away. Not so Fatou Bensouda. She took her time. And in 2020, she made a statement that she basically had finished up the preliminary examination and that she would normally ask for an investigation to be opened, but she asked the judges to look at territorial jurisdiction and could she in fact open an investigation. So that was a whole round of hearings. And then in 2021, the judges essentially said, yes, you have jurisdiction, and actually, you should open a case right away.
And then we've been waiting since that time. Where are we? 2024. So now what?
Well, there was always a lot of grumbling that they moved so slow on Palestine. And then after October 7, where Hamas and other militants broke out of Gaza, killing 1,200 people and kidnapping several hundred Israelis, it moved fairly fast. What followed a couple of weeks after that was the Israeli response, which consisted of massive bombardments and invasion of the Gaza Strip by Israeli forces. We have the latest figures, but they're climbing daily. The offensive killed nearly 38,000 people, according to the Gaza Health Ministry, and has left basically the heavily built up Gaza Strip in ruins.
I can hear the Reuters speak in that because that's exactly the kind of summary that you'd have to provide for the news agency that employs you. So why don't you bring us up to date on where we are now?
Since the beginning of the conflict, the current prosecutor, Karim Khan, basically warned both sides to stop doing things that might be crimes that fall under the jurisdiction of the court. On May 20th, he came out that he would ask an arrest warrant for Israeli Prime Minister Benjamin Netanyahu and his Defense Minister Yoav Gallant on charges of war crimes and crimes against humanity, mostly linked to starvation in the Gaza Strip, and 3 senior Hamas officials also on crimes against humanity and war crimes for crimes linked to hostage taking and the killings on October 7, and warned that there may be more applications for arrest warrants.
Now, thanks, obviously, for researching the dates and making sure we get the summary so we're all on the same page. But what we have seen over the last week or so is quite a few different kinds of statements and speculation about the idea of complementarity. There's such a weird word that we have to get used to, and we're so used to it covering the ICC, but I imagine the rest of the world is thinking, what the hell? Other media members might just have to be getting up to speed on what it means. And we've had Israeli and I think some US politicians spouting ideas that essentially, because Israel's officially a democracy and officially has a functioning independent judicial system, the ICC should just butt out. Again, essentially, no jurisdiction.
That is the argument that we hear a lot. So this episode, for the first part, is officially a debunk from someone who really ought to know. It's the special advisor on war crimes to the office of the current prosecutor, Kevin Jon Heller, who is also a professor of international law in Denmark. We kicked off by asking him where we get our understanding of complementarity. How do we know when the ICC can or can't prosecute a case because the state tells them, we're looking into this? Is it from the Rome Statute, the treaty that state parties negotiated in Rome back in 1998, or is it in the latest OTP policy document on complementarity that was just launched a few months ago? Where do we look to make sure what states have to do and how they have to do it?
I think you do have to look at both. I mean, I think the most important source is, of course, the Rome Statute. And, it's kind of notable that the principle of complementarity only actually appears in the preamble. It isn't specified in the statute itself. That said, of course, we have a couple of different articles that deal with complementarity. We have Article 17, we have Article 18, and Article 19, and they all kind of cover different aspects of complementarity. The primary provision, of course, is Article 17, and that's the one that basically says that the court has to defer to a national investigation or prosecution if the state in question is actively investigating the same suspect for substantially the same conduct and is neither unwilling nor unable to genuinely investigate or prosecute. So that's, the principle is quite easy in terms of being stated. It's, of course, the application and the interpretation of those very simple provisions that gives rise to so many problems.
When you're talking about same crimes, same conduct, that's been litigated through the ICC. So we are really talking, and you have to look at the same people and you have to look at the same kind of what the ICC alleges are underlying crimes or underlying facts. And then the difference can be that you don't have to charge the exact same crimes because not all national jurisdictions have the same labels for the conduct. Am I understanding that correctly?
Yes. There is a difference in terms of how complementarity is applied at the kind of opening and investigation stage versus how it applies in a particular case. But the basic principles are, as you said, kind of still the same. There is no flexibility with the same suspect aspect of the test. If a state is not investigating or prosecuting the same suspect that the OTP is looking at, that's the end of any complementarity challenge. In terms of the conduct requirement, in the old days, the court was very, very strict about this, and it was essentially same conduct. It really wasn't until the Kenya cases where the appeals chamber said not the same conduct, but substantially the same conduct. And of course, again, the devil's in the details there. What does it mean to say substantially the same conduct? And that then kind of brings you to the Libya cases. And the early part, or the pretrial chamber in the Libya cases, they had a very kind of holistic, kind of complementarity friendly investigation that said, just kind of compare the two investigations. Do they seem to be substantially the same? But that, of course, was kind of overruled by the appeals chamber. And the appeals chamber in the Libya cases said very clearly, when you're talking about substantially the same conduct, you are talking about individual incidents. You look at the incidents that the OTP is investigating, you compare those incidents to the ones that the state is investigating, and unless there's substantial overlap between the two, the state is not, in fact, investigating substantially the same conduct. So it's more flexible in terms of the structure of the test, but in terms of the application of the test, we could debate really how different it has become. But that isn't, again, that is the test that they apply.
The way that you put it, Kevin, it sounds like this has been an evolving policy, and that it's something that it's quite difficult to say, because it's been like this in this case, it would be exactly the same in another case, because maybe different judges, maybe because of that kind of sense of the Rome Statute still, the system finding its way. But I'm wondering, because obviously we're concerned particularly about Israel-Palestine, and we know that you can't comment directly on Israel-Palestine, but what should we be asking ourselves about the possibility of state arguments to the ICC, looking back at previous examples? What might happen?
Well, I mean, I think probably the most important consideration in that situation, and this one tends to get overlooked, is the activity requirement. Is the state actively investigating or prosecuting the same suspects for substantially the same conduct? It isn't enough to just say, hey, we're going to investigate suspect X. You actually have to show that you have taken to quote the Gbagbo chamber, you have to show concrete and progressive steps toward an investigation. And that's actually quite a high bar. And in my previous life, before I was a special advisor, I was extremely critical of the jurisprudence in the Gbagbo case, where they arrested her, they detained her, they opened case file against her, they interviewed witnesses against her, they specified the charges against her, and the court still didn't find that enough to find that Cote d'Ivoire was, quote, active with regard to Simone Gbagbo. So you really do have to show that you have taken very concrete and progressive steps toward an actual prosecution to satisfy the court. So we need to look at what would a state like Israel, or what is a state like Israel doing to deal with one of these suspects. Frankly, if Palestine wanted to bring a complementarity challenge, they would, the inquiry would be exactly the same, and we would have to look at, are they going after Sinwar, Daif, and Hanea, and what have they done to advance the investigation? And that's the threshold consideration. If you can't show that you're active with regard to a suspect, none of the other parts of complementarity even matter. Your complementarity challenge immediately fails.
What I've heard and read is that there is speculation that in Israel there could be some kind of a commission of inquiry into what happened around the whole set of circumstances that led to the current war in Gaza. And that seems like kind of a logical thing that a state would do before somebody hairs off down the road to open an investigation. Is a commission of inquiry enough?
It depends on the commission of inquiry. We wouldn't want to say, as in the abstract, that no commission of inquiry could ever satisfy complementarity. We can imagine one that would. It would have to be one that really had, concrete legal investigative power. It would have to have the ability to look at individual suspects. Realistically, I think it would also have to have the power to actually not just recommend charging a particular suspect, but actually to have a binding decision about whether a suspect is charged. And, I'm not an expert on Israeli Commission of Inquiries, but I did do a little bit of research. And as far as I know, there's a whole bunch of different types in Israel, but that none of them, even the one that has the strongest legal power, can't actually make binding decisions about whom to prosecute. All they can do is recommend. So, this would ultimately be an issue for the judges of the pretrial chamber. I don't know exactly how they would decide it, but I think it's very unlikely that a non-binding commission of inquiry would ever satisfy the principle of complementarity. I don't see how it could.
Well, we have one example, of course, of a commission of inquiry meeting complementarity, and that's the UK-Iraq for the Abu Ghraib abuses. I know that's a very different commission of inquiry. And I wonder also, does it not, if we look at the Israel case, are we not kind of too far down in the process to now come up with this commission of inquiry and start cooperating? Because I understand also that, they didn't file a complementarity challenge under Article 18 when they opened the investigation. So now they can file it under Article 19, but then usually you do that after you have an arrest warrant confirmed, so you know what same conduct, same charges you have. So if you look at the position of the timeline of where we are, does that make a difference with the things that you can do?
I think it makes a huge difference. I don't want to say that a commission of inquiry couldn't be relevant even now that we're really dealing with concrete suspects and concrete, at least, sought charges against them. But there's no question that earlier in the process, particularly at the stage where the OTP decides to open the investigation, it is a much more kind of generic, broad complementarity inquiry, because of course when the office of the prosecutor decides to open an investigation, all they know is maybe the general classes of people they're going to investigate, the kinds of crimes they really want to look at. Maybe they have some sense of which incidents are the most important, but they haven't really narrowed it down, and they don't have to narrow it down at that point. So if a state files an Article 18 challenge and says you have to defer because we are conducting national investigations, there the state will be cut a lot more slack. I don't know even there whether particular types of commissions of inquiry would satisfy, but certainly if a state could show, listen, we are making a good faith effort. We're looking at all of the suspects that we think that you might want to look at. We're looking at a very broad range of serious crimes and paying attention to the particular acts that you have pointed out, you being the OTP. There, I could see a complementarity challenge having much greater chance of success. And then kind of even beyond that, just real quickly, this is a prosecutor who has a very different approach to complementarity than his predecessors. He has emphasized again and again that he will work much more proactively with states and give them more of the benefit of the doubt, as long as he is convinced that they are genuinely trying to end impunity. So even if a state, even before the opening of the investigation, had really engaged in good faith negotiations and discussions and sharing concrete information about what they were trying to do, there you might not even have had to been in the whole formal Article 18, Article 19 area. You might have been able to get a lot more slack from the prosecutor, again, maintaining vigilance to make sure that they're not, just trying to insulate people from accountability, but really are trying to do the right thing. That would have been, I think, much more effective with Prosecutor Khan than either of his predecessors.
Do you think it makes any difference in approach whether we're talking about state parties or non-state parties to the Rome Statute in this?
Any state has any state that is investigating or prosecuting the same suspects for substantially the same conduct have the right to bring a complementarity challenge. They don't have to be a state party, and I think that's pretty clear from the drafting history and also from just the wording of the relevant provisions in the Rome Statute, although that was definitely something during the drafting of the Rome Statute that was quite, I don't necessarily want to say hotly debated, but it was certainly discussed at some length.
Final question. We always do, what didn't we ask that you want to tell us? So you get the opportunity now to go for what is the one thing about complementarity that you want to set right, or that you want to make clear that everybody who listens to this podcast understands, and that you don't have, once more for the people in the back.
Mm-hmm. Well, I mean, what's always nice about talking to you guys is you tend to ask the right questions. So I would really just emphasize again that we cannot overlook the activity requirement. It does not matter how busy a state like Israel is in terms of pursuing other suspects for other crimes, even if they have a completely functioning legal system, even if they have a thriving democracy, none of that is relevant to the Article 19 complementarity analysis. The only thing that we care about is same suspect. So in this context, Netanyahu and Gallant, for substantially the same conduct. Nothing matters to complementarity other than that. On the flip side, the fact that hypothetically a court would reject a complementarity challenge by Israel or by one of the suspects says nothing about the quality of the Israeli judicial system. It says nothing about whether Israel is a democracy. Those are not considerations that are relevant to complementarity under Article 19. It is a very formal technical test that has to be satisfied, but the implications of losing a challenge don't go beyond you didn't go after the same suspect for substantially the same conduct. That's it.
So before we go on to our next guest, I'd just like to say what fun it is to realise how much time you, Steph, are spending reading the Rome Statute and trying to get your head around it, just like me. And I do think this is a shout out to any journalist. Oh, you're just flashing a copy of it at me in the podcast. Maybe we'll take a screenshot of Steph with her own personal copy. Really, media, if you're listening to this and you want to report on this, then you have to find these kind of short courses to get yourself up to speed. I've run some myself at different times over the years, and I really hope, and I just encourage colleagues to delve into the details, because this detail really matters and it really helps with reporting on this stuff.
I get a lot of laughs when I pull out the fact that I actually have indeed my own paper copy of the Rome Statute next to my computer at home that is well thumbed, and there's lots of little notes in the margin and highlighted stuff. And I go back to it a lot just because that is the thing that it's all resting upon. And if you want to understand what's going to happen and what courts must do and what the ICC can do and can't do and what it must do, it's in the Rome Statute.
And the other thing that we have to always check is what are the filings? And we have to check on the website who has filed what. So the latest filing is...
The latest filing is we got a sudden decision by the judges in the pretrial chamber allowing the United Kingdom to file an amicus brief in the Palestine situation. And they, in this document, they said that they filed this specifically after the prosecutor asked for arrest warrants. So let me run through a bit of what we're talking about with this filing.
Now, just to start with, Steph, I call it an amicus. You call it an amicus. I think both are potentially okay, but I just want to say if anybody wants to correct us on that, you're welcome.
I think there's a difference here between how we are taught to pronounce Latin in Dutch Latin school and potentially in UK schools or in court.
This is probably true.
Now I'm self-conscious. An amicus or amicus brief is a friend of the court filing or recommendation on a legal issue that essentially state parties or other interested parties at the ICC or any other court can ask to file. And in this case, the UK asked, but was also granted that right. What became clear from the UK submission is that it wants to argue that because the PLO signed up to the Oslo Accords, setting up the Palestinian authorities, it agreed to some stipulations in that accord, which agreed that the Palestinian Authority has no jurisdiction over Israeli citizens. And now comes the kind of legal bit where the ICC is involved. Some scholars argue, and the UK now is also suggesting, that because the Palestinian Authority, through the Oslo Accords, has no jurisdiction over Israeli citizens, it cannot transfer that jurisdiction to the ICC and tell the ICC you should judge the Israeli citizens in our name.
And this is an issue that's coming up right now rather than having been litigated and solved earlier on because?
Well, it's hard to say. I think London is coming up with this now because it's concerned about the warrants, and it keeps repeating that it believes that the ICC has no jurisdiction. In initial filings, I think it claimed something else and the Oslo Accords, but after we had Ukraine-Russia invasion and everybody was fine with the ICC prosecuting members of a non-state party, Russia, for alleged war crimes in Ukraine. A lot of countries can't make that argument anymore. So we're back to the Oslo Accords. I have to say the Oslo Accords were mentioned in the initial 2021 decision, and some people made the Oslo Accords argument, but the judges kind of waved it away and said, we're going to deal with Oslo at a later date. For now, we're just going to say territorial jurisdiction, and that's a yes, and you can check the Oslo Accords out later.
I suspect that this is something that we're going to see argued, but to help us through the legal curveball that this may have thrown to the judges, we asked another bigwig. This time, she used to be Fatou Bensouda's advisor on crimes against humanity, and during a particularly crucial period, while the court was thinking about all of these decisions around Israel-Palestine. And she's now professor of international criminal law at Washington University in St. Louis, Missouri. And that's Leila Sadat. And we kicked off by asking her, what exactly has the UK alleged in this amicus?
What's interesting is the UK hasn't yet filed its papers. What it's done is it's filed a request to intervene with an amicus because of the highly, and I'm just pulling it up actually because I don't want to misstate it. The UK argues that the issue of the Oslo Accords prevents the ICC from moving forward with the arrest warrant application of the prosecutor.
Yeah, as I understand it from what I read, is that they say that when the Palestinian authorities signed the Oslo Agreement, they agreed that they couldn't have jurisdiction over Israeli nationals. And so the argument is that they can't then hand over or defer jurisdiction to the ICC to look at.
Yes, and that argument turns the jurisdiction of the ICC totally on its head. And there's no other nice way to say this. It's completely wrong. The ICC's jurisdiction is not derived from the criminal jurisdiction of states in each instance, or the court would potentially literally have 193 different bases of jurisdiction in every case. We don't look at whether Ukraine has ratified the crimes against humanity provisions of the statute, for example, to see if the ICC had jurisdiction in the recent arrest warrants issued in Ukraine. We don't look to the national law of the territorial state, whether in its criminal code or as affected by its treaty relations with others. Once a state confers jurisdiction on the court has jurisdiction over that state's territories and its nationals, regardless of the specific details of what the state has in its national system. Does that make sense? So in other words, the states confer jurisdiction on the court. They don't delegate some sort of derivative jurisdiction to the ICC.
I understand what you're saying. You said they confer this jurisdiction and then it's territorial. And that is what the judges decided in 2021. But then they said we're only looking at the territorial bit. And all these Oslo Accord arguments, we're going to table that for now. And they might come up later. And so now is later in that sense. And now people are bringing up these Oslo Accords again. So regardless of what you think about the interpretation of the Oslo Accords, it seems that the judges are giving some kind of significance to them by saying, we're not going to rule on them now, we'll do it later.
You know, I didn't actually read I suppose that's one possible reading of the decision. Stephanie, I didn't read the decision that way. I simply said, I do think that it was an invitation to states to some degree to say, if you want to come back to us with additional arguments, feel free to do that. But I don't think it was necessarily an invitation to do so. I didn't really read it that way. Obviously, the UK reads it that way, but that's not how I read that pretrial chamber decision. The pretrial chamber decision was, do we have jurisdiction over the situation in Palestine? And the pretrial chamber said, yes, you do. And here's the territorial scope. It didn't opine on Palestinian statehood, qua statehood. It didn't opine on other relations of Palestine with other countries because those issues weren't before it. But that's not the same as saying, oh, there's an invitation to come back and challenge jurisdiction under Oslo.
Okay, fair enough. I read it after I read what Britain had to say about it, so that might have influenced my diagonal speed reading of the original ruling, I have to say.
Yeah, I think so. And the British are actually trying, I've written a very big article on this where the new argument of folks, it's not so new with respect to Palestine, but Israel's standard argument is you have no criminal jurisdiction over us under Oslo. We're going to set aside the argument one might make that that's an illegal agreement, because to say to a state that it's depriving itself of criminal jurisdiction, Mahmoud Abbas has repudiated that, and the Palestinians have repudiated that already. And I wonder whether that even has effectiveness. But assuming it has some effectiveness, I think right now the UK is using that because it's been rebuffed on all the other sort of iterations of the delegation theory, which is basically a theory that the ICC only has what states give it in a very limited way. And that is the argument that was used by the United States and Israel to argue there's no jurisdiction over the nationals of non-states parties. And the reason they can't use that argument anymore is because they've agreed that the ICC has jurisdiction over Russians. And so they're limited to the Oslo Accords because they want the ICC to have jurisdiction over Russians, but they don't want the ICC to have jurisdiction over Israelis. So I think it's somewhat disingenuous of the United Kingdom to be using this argument, because it's just another way, I think, of delaying the proceedings. It's a form of political objection to the court's intervention in the Palestine situation because the UK doesn't like it.
When we were speaking to Kevin Jon Heller earlier about a different subject that was specifically on complementarity, he asked us to ask you a question, which I'm sure he would phrase differently. But so this is my summary of what he asked. And to say to you, but why is everybody getting so het up about this? Because isn't Oslo just a treaty like any other treaty? And Palestine could just sort of say, well, we're just not abiding by Oslo because we're going to do stuff with the ICC. So, well, why are people arguing about this?
Well, I don't disagree with Kevin. And as I said, the Mahmoud Abbas has said that already, that we're not going to comply with Oslo. We're repudiating it. It's sort of an unreasonable agreement when one thinks about it, right? A treaty contra bonus mores, which actually requires a state. But, the Israelis don't really call it a treaty because they would then have to admit that there is some capacity of Palestine to enter into treaty relations with Israel. So I think that's why I say this is sort of an ever-shifting narrative that is trying to deprive the state of Palestine of its own ability to accede to the ICC statute and place its territory and its nationals under the jurisdiction of the ICC. So I don't feel that the UK has sound legal arguments, and this feels more like a political argument. That said, there's a huge amount of literature obviously coming from the Israelis and from some scholars in the United States that argue to the contrary.
One of the things that Kevin also said is, even if this is a treaty that is functioning and they break it by kind of deferring, if you agree everything, right, that this is a functioning treaty and that you can defer jurisdiction to the ICC, then the fact that they're doing it just breaks the Oslo Accords, and that's a breach of treaty, and that's a different forum than the ICC. So the argument is it shouldn't be at all a consideration by the ICC, because then it would be just the Palestinian authorities deciding to break a treaty, and the treaty law is a different kind of court. The ICC doesn't have to look at that.
I think it's very similar. I think Kevin's actually quite right on that. And the ICC situation, Roger O'Keefe has written a very good piece on this, and you've probably seen his blog in Opinio Juris, where he sort of makes the same argument. And the other thing is that, in the al-Bashir immunity decision, I think we've already seen from the appeals chamber that they do treat these horizontal relationships between states as different than the vertical relationship between the ICC and the state that accedes to the Rome Statute. And the ICC's consistent position, whether it's the Palestine situation, whether it's the Bangladesh-Myanmar situation, whether it's in the complaint that South Korea brought against North Koreans committing allegedly ICC crimes on its territory, the ICC has been very clear that its own jurisdiction is not subsidiary to or dependent upon states. That once states accede to the Rome Statute, the statute applies in its entirety. And I think that's clearly the right decision. It's a very consistent holding, really, since the inception of the ICC, and very consistent with the negotiating history of the court.
In the decision of the judges, it also says that, we are granting the UK the right to file this Amici brief, but we expect others will also file. I think he gave a deadline for July 12th, and you can only file 10 pages. But do you think there will be many other Amici Curiae briefs, and how many are you really expecting? Should we have an avalanche of things? Is everybody kind of sharpening their pens to get ready about this? Have you heard anything?
I have. I think there will be, when pretrial chamber took this up earlier, there were, I want to say 43 submissions. There were quite a number of submissions. There were several states. I would say Germany was the state that already in that earlier decision in its amicus filing, Germany is the state that most closely voiced the arguments that the UK is now making, which was basically Oslo, that the Palestinians have given away their criminal jurisdiction, and therefore they don't have that jurisdiction to delegate to the ICC. Whether or not states like that are going to come in now, I think the fact that the General Assembly just came in with even more enhanced status of Palestine as a state in the General Assembly, the fact that the Security Council resolution granting UN membership would have passed but for a US veto, I think is going to give some states pause about intervening in the same way that they would have done, not because of what's happening in the ICC case, but because of the genocide case that's going on in the ICJ. I think many states are concerned about the civilian casualties resulting not just from October 7th, obviously, but the Israeli response. And that may make states a little more hesitant to come in with these jurisdictional arguments. And as I said, Stephanie, ironically, these are the same arguments the U.S. made about itself and would have made with respect to the Russia-Ukraine situation, except, the political winds favor the ICC's intervention in Ukraine. And so the issue of double standards is really front and center here. So I don't see that many states coming in. I may be wrong, but I think some states will hesitate to weigh in against the Palestinians. Not that many weighed in the first time. I mean, there were 5. And there are going to be some scholars who are going to weigh in for sure. I think we will definitely see scholars. As I understand it, though, they have to give notice of their intervention before July 12th, and then presumably they will be able to respond either in support or against what the UK has written.
There's a lot of speculation over how long the judges could take to make a decision on the applied for arrest warrants. And then with this as well, do you think this might mean there could be some kind of a delay?
I think that's the big disappointment, is it seems to be a delaying tactic. Again, we don't know what the pretrial chamber would do. I wouldn't presume on its judgment, but we already have one pretrial chamber decision, which I did read as saying we have jurisdiction in this case. So I think that the decision to file is a potential delaying tactic because we don't know how long the judges will take.
So, Steph, final thoughts. I'm wondering, you asked Leila yourself, do we expect other Amici, I think that's the plural of amicus, to join in this? Is that what you're hearing?
Yeah, I expect so. I think that we've seen a lot of kind of resistance to this request for arrest warrants of Israeli officials, also of countries that generally support the ICC. And they've all kind of said that they support the independence of the ICC, but make some legal arguments about why they maybe shouldn't be looking at Israeli officials. This, of course, is their way to make that argument. And also maybe it's also just a cynical time tactic, because the more things that you file, the longer the judges might have to mull and read all these documents. And on the other hand, you will have all the people and organizations and governments who feel that this is nonsense and the ICC should have jurisdiction, and they will all, I think, also try to request to file Amici briefs in droves because they want to counter this tactic. So I think both sides of this argument will try to make the legal argument and make as much as they can. And then you kind of see this fashion also, that everybody is now filing all these interventions and support statements. It's becoming, saying that you're going to do it or intervening in a case is now also kind of a political a PR move in a way.
Yeah, I'm sure because you cover the International Court of Justice, you see a lot more of that going on that side. I'm wondering, are you aware whether the Israeli state as such is kind of particularly engaged behind the scenes in this process? I mean, while I was living in The Hague, I was aware of them having a legal advisor within the embassy, and, you know, they were definitely following everything.
Obviously, they're following, if you read The Guardian, they're following probably a little too closely, and maybe not with all the best agencies, because they have all these articles about the Mossad essentially following what the ICC is doing. I feel in this, Israel kind of straddles the line. I think they do officially engage, but keep it to a minimum. I think they have to engage on some official level, but I think they also want to keep some distance between themselves and the ICC as the government, so that you want to keep a kind of plausible deniability as a government. I think that's kind of the strategy, where if they go full in and engage fully with the court, they can also not make this argument that this is a sham court or like a show court or a show trial or super biased, because you're actually engaging with it. So you want to engage just enough officially to not be dismissing it entirely, and also because your allies think that you should do at least something to maybe minimize potential risk of grave violations of international human rights. But you also don't want to engage too fully, so that you can't then later turn around and say that was all a patch-up job and that you were stitched into it, you know. So they have this weird kind of middle position, and I think they will keep that.
And the big question, obviously, that everybody asks is, when might we expect the judges to rule on these potential arrest warrants? I remember in a previous podcast, you'd done the sort of maths of the average amount of time that it could take and the longest that it has taken in the past. And of course, past performance is no indication of exactly what will happen this time round. But what's your best guess?
Well, if you look at this filing or this decision, you see that they said that they would entertain other requests for interventions. They have a deadline of July 12th to get other requests. Then they have to decide if they are going to agree to those requests. Then they'll put a deadline for people to write their amicus briefs. I think they gave the UK 2 weeks after their decision to allow them to make a brief to put it in. So if you just look at the way that works, let's say they're super speedy and within a week they decide who can put in other briefs. They give them 2 weeks, then we're already kind of a month on. Then you have summer break for the court. Also, they have a period where they don't have any hearings. And then I think this kind of pushes it back to not before the end of August.
Oh, God, at the very earliest, I think. Very, very earliest. But yeah.
But you know what they say in the Netherlands? They say guarantees till the door. So this is my idea, is that this probably pushes a decision on the warrants over the summer judicial recess period.
Okay. Well, that's it then for this week. As always, thank you so much, everyone who's listening. And we thought we'd just give a quick shout out to those who support us on Patreon. We haven't done this for a little while, so there's a few names we need to read out. These are people who are following us on Patreon, either providing us with a bit of cash to buy a coffee occasionally, or at least they're supporting us just to get our newsletter. So, you're welcome to do that as well and get your name read out.
So we welcome Christopher Stephen, Udolum Ninandi, Erica Oliveira, and Lindsay Freeman.
Particularly welcome to Lindsay, who's also a friend of the pod. She's been on before. Caroline Howard, Kate Clark, Camille Aubert, and Helena Prokopishina.
And we have Bob Cutt, Solveig Goet, Rebecca Hawkins, Andrea Costea, and Kaylin Goodluck.
Particularly want to say thank you to Solveig for supporting us, because I know her here in Lithuania.
Thank you all for supporting us and getting our newsletter, listening to the Patreon, and just listening to the pod. It's already this month again, we passed 10,000 downloads, which for us is a big deal that all these people listen to our little pod. So thank you so much for listening and keeping it interesting, and let us know if you have suggestions, ideas, our email numbers, and how to get in contact with us is all on our webpage, www.asymmetricalhaircuts.com.
This was Asymmetrical Haircuts, your international justice podcast, created and presented by Janet Anderson and Stephanie van den Berg. This episode was produced in partnership with justiceinfo.net, an independent site covering justice effort for mass violence. Music is by audionautics.com, and you can find show notes and everything about the podcast on asymmetricalhaircuts.com. This show is available on every major podcast service, so please subscribe, give us a rating, and spread the word.